2025 mid-year conference held at the Labadi Beach Hotel, Accra, on Saturday, the 26th of April, 2025. So that was just a few days ago, actually, just this past weekend. All right. Now, this reads as follows. We, the members of the Ghana Bar Association, herein assembled at the 2025 mid-year conference of the bar at the Labadi Beach Hotel, Accra, on this day, on the 26th of April, 2025, stand united in our collective responsibility towards advancing the rule of law, justice, and the sustainable development of Ghana. Recognizing the profound and pivotal role the legal profession plays in shaping a just, fair, and transparent society, and reasserting our commitment to upholding the rule of law, ensuring justice for all citizens, and promoting high standards of integrity within public life, acknowledging the central tenets of the 1992 Constitution of the Republic of Ghana, particularly those enshrined in its preamble, which binds all citizens and the state to the principles of freedom, justice, probity, and accountability, emphasizing the key role the legal profession plays in national development and in the administration of justice, conscious of the overreaching goal of ensuring the continued respect for the rule of law and strengthening the legal frameworks that govern our institutions of state, and in furtherance of the theme for this mid-year conference of the bar, which is expanding the role of the legal profession in national development, positioning the GBA as the fulcrum, hereby resolve and declare as follows. Matters affecting the legal profession. What a preamble that was. Let's get into it. 1. Withdrawal of directive on assignment of courts and fixing of dates for newly filed cases and applications. Recognizing that the directive by His Lordship, the Acting Chief Justice, on the assignment of cases by his office is uncertain, and having regard to the importance of technology and the urgency of justice delivery, the Ghana Bar Association respectfully requests that this directive be withdrawn and the use of technology in the assignment of cases to the courts enhanced. 2. Suspension of the Chief Justice. A. Revocation of suspension. Now, the Ghana Bar Association calls for the immediate revocation of the suspension of the Chief Justice, as it considers the suspension to be unconstitutional, considering the fact that the president, who is not a judge or a judicial officer, exercised his discretion to suspend the Chief Justice under Article 14610 of the 1992 Constitution in the absence of a published constitutional instrument, statutory instrument, or regulations governing the exercise of his said discretion as required by Article 296 of the 1992 Constitution. B. Enactment of regulations. The Ghana Bar Association hereby also calls for the immediate enactment of clear and comprehensive regulations relating to matters under Article 146 of the Constitution of the Republic of Ghana to ensure transparency, accountability, and fairness in all proceedings involving Superior Court justices, particularly in the context of the impeachment or removal of such officers. C. Release of decision on prima facie case. In addition, the Ghana Bar Association calls upon the President of the Republic of Ghana to immediately release the full decision establishing a prima facie case against the Chief Justice, consistent with established precedent. Now, this disclosure is necessary to ensure that the process is conducted in accordance with the principles of transparency and fairness. And D. Denunciation of prejudicial comments. Furthermore, the Ghana Bar Association denounces any and all unsubstantiated political commentary or statements that seek to undermine the authority, independence, and integrity of the judiciary. The association affirms its commitment to safeguarding the sanctity of the judicial process and resolves to take all appropriate legal measures to protect the judiciary from undue interference or unjustifiable attacks. They also talk about matters affecting the nation. 3. Galamsey and destruction of the environment. Acknowledging the grave threat and that illegal mining activities, in bracket Galamsey, pose to Ghana's environment, water bodies, farmlands, and public health, the Ghana Bar Association unequivocally condemns the ongoing galamsey activities across the country and calls for immediate, decisive, and sustained action by all arms of government, law enforcement agencies, and relevant stakeholders to eradicate the menace. Beg your pardon. It's long. It also urges the judiciary to prioritize. I said the statement is long. The resolutions, there are many. Bear with me. Apologies. Urges the judiciary to prioritize and expedite the hearing of galamsey-related cases, ensuring that offenders are held accountable in accordance with the law without fear or favor. They also talk about the Boku conflict, all right? It goes on to say the Ghana Bar Association, noting with deep concern the conflict in Boku, and Crosby, prod me if you need me to.
So let's pause on this part, because
right.
it is, like you said, it's very long.
It was getting longer and longer.
Yeah, it was choking you. So
all right. Wow.
And let's
bring it back down. If you're watching on Facebook, let's bring it back down to the issues concerning the CJ, right?
Yes, the CJ.
Then we can all follow
limit
along.
it to the issues concerning.
We'll truncate the.
I'm sure that is shorter enough.
They're reading, indeed.
Success Olo, you've heard the GBA.
For Helen, you want me to do what?
Say again.
Helen says it's too long for her. You are now giving it to me.
No, we've reduced the length
to
now, so we're now limiting it to only
Resolution 2, is it?
Yes.
Suspension of the Chief Justice.
Yes, the revocation of the suspension, the enactment of regulations, the release of the decision on the prima facie case, as well as D. D is what? The
denunciation of
prejudicial comments. Frederick, if you could scroll so we see what the D is telling us exactly, so we know what that means. So these essentially are the demands of the Ghana Bar Association. Sisters, are you surprised by their position right on some of the demands they're making? Does it sit well with you?
I'm surprised.
Why?
I'm surprised because just a week or two ago, we were all celebrating the Ghana Bar for the statement that it had released.
Were we?
Yes, we were.
Okay.
We were because for some time now, the statement, the bar had taken a certain posturing that we had not seen before. A posturing that suggested that the bar wanted to allow the processes to flow, to observe the processes without passing such comments as had been done in the past, which drew public, criticisms to the bar. Some for some of the reasons, some of the statements that had been released in the past, the bar had been seen as a partisan, had been attacked by members of the political divide, depending on whether their statements sat well with you or not. So this particular statement that we saw a week or two ago, it was celebrated by, in fact, members of the bar themselves, where if you went through social media, you saw that they were saying, oh, now we are seeing a bar that seemed to be apolitical, that is appearing to say, let us allow the processes to flow. Let us all follow the processes dispassionately and ensure that the right thing is done.
In fact, spokesperson for the president actually wrote on his X page and Facebook wall commending the statement.
That's
he says,
Felix.
Felix, yeah, he
and
said,
Felix is not a member of the bar.
Yes, he said actually this seems a bit different to usual, and he commended that.
Yes.
That release.
And so he wouldn't have been the only one. There were quite a number of political figures who would have been impressed by that statement, and also the independent watchers, civil society players within the legal space who were impressed. And just when the applause was yet to die down,
they have poured gatherings at it.
Now the thunderbolt is released, unleashed on us. I mean, you see, I am worried that for those of us who are looking from the outside, that when such a powerful body like the Bar Association speaks, the weight that it carries, the impact that it should make, we are not seeing it. The bar should not make, and it's the same argument I have been making about the Ghana Journalists Association.
Right.
That the moment the bar speaks, it should not raise controversies as we are seeing. It should be a time of reflection for anybody or any authority or any power against whom the statement has been released. But we don't seem to be seeing that with this statement.
In fact, if the bar speaks and like the GJ and other institutions, it should almost be like maybe a former president, a statesman, positioning on national issues. Maybe President Kufuor, for instance, he's talking about Galamsey. When he says anything about a subject like that, it should not be open too much to a lot of criticisms. There should not be a lot of holes. It should not allow it to be punched.
And I give you an example from the statement. The first thing has to do with the declaration of the action of the president as unconstitutional. I am not a lawyer. I'm not a member of the bar.
Yet.
And the members of the bar.
The man is getting away from the hole. You are pushing. And why are you doing that?
The members of the bar know the law better than I do.
Okay.
But you see, you cannot declare. Nobody can declare an act unconstitutional. Only the court can.
The Supreme
Court can.
Yeah.
So if the bar wanted a declaration of the act of the president as unconstitutional,
they should have gone to court.
They should have gone to the Supreme Court. And the bar has done that before. This wouldn't be the first time. So to release a statement declaring an act, an executive act, an exercise of discretion for that matter as unconstitutional.
An exercise of discretion allowed in the Constitution.
Yes. So this is a constitutional exercise of discretionary power by the executive.
Look, there is a 28th July 2023 release from the Office of the Judicial Secretary.
Right.
The one who has resigned now. Justice Cynthia Pamela Addo, now granting, right? She was the Judicial Secretary. It says, notice of suspension on electronic case distribution system. Respectfully, I write pursuant to the directive to suspend the electronic case distribution system. I have been directed by the Honorable Lady Chief Justice to inform you that the following supervising authorities are hereby mandated to take over the manual distribution of cases with immediate effect in the following areas. It talks about Greater Accra region, talk about the Ashanti region, and then there's distribution list to a very tall, about 23 or so persons who have copied, all judges, etc., registrars, and name them. Now, the Bar Association again in this statement, and I like the points that you raise, that when the Bar Association or any other institution like that speaks, the kind of weight that it must carry, you want to come to the center and say that, look, this has been well thought through, this has been, well articulated, and it brings finality to the matter. Mind you, in less than a week, the Bar Association has spoken twice on the same matter. The first one was just quoting the law to us and telling us that we should always be transparent, blah, 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 blah. But I'm sure the Bar Association was in this country when Her Ladyship, the Chief Justice, right, took the same decision that His Lordship Justice Bafoboni has taken. What did the Bar Association say then about this manual distribution of the cases? They knew that we had put in an electronic system. And this morning I said something on Johnny's Bite. If you go back to the list of judges that we have at the Supreme Court, there are some judges who have never sat on any case before, since Her Ladyship of Chief Justice assumed. In fact, some appeal court judges have never been, and these are from inside sources.
They've never used their courtrooms, if you like.
No, they've never been empaneled. There's the president of the court that will empanel you. So if you have not been called, what are you going to do then?
And Johnny, we'll get into
And then you get to a point where judges are changed. And the gentleman you just spoke with, judges are changed on the day that they are supposed to be giving judgment.
The Ajeni Mboating case, for instance.
Look, So where was the GBA when all these were happening?
We'll go into the demands of the GBA shortly. And Frederick, let's start with the very first demand of the Ghana Bar Association in relation to the ongoing happenings concerning the removal of the Chief Justice. The very first one, before we get to the directive by the good. So if this is the beginning, the suspension of the Chief Justice, the association is calling for immediate revocation of the Chief Justice's suspension, deeming it unconstitutional. I don't know, Helen, you're not a lawyer, right?
Before you even land, I also don't know. Trust me, I know what you're going to ask me. Before you land, I also don't know, because we weren't given further and better particulars. I mean, for weeks on end, we've opened up our constitution. We've read ad nauseum what the steps are, and at this point, all of us, including all our listeners, know what the process is to get the ball rolling. I don't know at which point the constitution has been breached. I don't know at which
maybe
point.
They should explain to us.
I don't know
what exactly happened there with all the processes we've followed up until now. Which part has been unconstitutional that we know we can measure it against some parameters?
Yes, I think for me and everybody else,
that is the point
be
that I was on.
helpful.
That if we all agree that the president has acted constitutionally from day one up to this point, the exercise of the discretionary power to suspend the Chief Justice. That is where the GBA is taking an issue with the president. And that's where you see bullet number 2, that there should be an enactment of clear regulations to guide Article 146.
So is this to say that the provisions in the Constitution concern the removal of the Chief Justice is not adequate enough? We need to, add some more.
In fact, it is one of the things that Johnny and Helly is one of the things that all lawyers agree on. You see, lawyers always disagree. It's one of the things that all lawyers agree on, and it's, you see, one of the that a bar pronouncements in one of the cases is one that keeps coming up in these conversations, that we do not have a clear procedure laid out. And so it is important that we do that.
Okay, but what is there?
Relax for me. And since that pronouncement, Parliament has not acted on it.
Maybe the Constitutional Review Committee is working, so maybe they would look at it.
The Constitutional Review, this particular committee, you mean the HKP's own? Okay, so that is where we should see some action. But to say that the act of the president is unconstitutional, it should not come from a resolution of the GBA. It should come from the declaration of the Supreme Court. And so I would have thought that based upon deliberations at the mid-year conference,
right,
and convinced that the president did not act properly or constitutionally, the GBA would have then proceeded to the Supreme Court and given the agency of the matter. The Supreme Court would then have granted audience so that the act of the president is brought before the court for the Supreme Court to then pronounce on the constitutionality or otherwise of it.
Right.
But it should not be a resolution of the GBA to make. It shouldn't be.
Let's speak with.
It's actually not within their remit.
No.
So to make the only, and in fact, if you go back to the Daniel Domolevo case,
right,
a 9-0 decision, right, by the Supreme Court said that Mr. President, sacking of Domolevo was unconstitutional. It is their job to interpret the Constitution.
So notwithstanding that, it came a little too late.
1061 or 62, huh?
It came a little too late. But you see, the good thing is that at that point, the Supreme Court had pronounced on it clearly. And so going forward, there will not be the case that somebody is coming to remove an Auditor General because the person disagrees with the Auditor General. Because now the Supreme Court has helped us with that law. And that is what we should expect in this case. Especially that, you see, this case has generated so much political interest.
Right. That's right.
And the bar is lending itself to
the politics of the
politics of the day. And if we are not careful, it will be drawn into that politics, and the bar will be the ultimate loser in this matter.
I tell you what, a former leader of the bar, right? The two former leaders of the bar, the Attorney General, Godfrey Ebo-Adami, and then recently lawyer Sonaba Dapa, who was also deputy AG, right? They had led the bar before, right? At the time when Charlotte Osei's head was brought onto the chopping board, Mr. Dami was at the Attorney General's department. Was that his posture? He supported, he went all out for it. What has changed now?
Interesting you mentioned that. So the leader of the bar is the Attorney General. And I was listening to the Deputy AG speaking on a different platform. He says that the AG was not present for this meeting.
Mention the Deputy AG.
Some are saying that they have 8,000 members or so, and there was just about 50 or 60 of them.
47 or so.
No, you see that argument too cannot. It cannot hold.
Okay.
Because all can't say that.
It works with every organization works with quorum. So if you was the agenda for the conference the not circulated, there was notice of the conference meeting. There was agenda circulated in addition to. So if you thought that you had an interest in a particular item on the agenda you didn't show face there, you allowed a few people to go and take decisions and pass resolutions on your behalf. Once the resolution is passed, it's binding on all of you. As for that one, there may not get problem.
Let's listen to the Deputy Attorney General. Just to refresh our memory.
That reasoning is faulty. It's faulty in the sense that it is assuming that when a CI is not published, then the person who is given the power to exercise the discretion cannot exercise it. That is not the proper. It is not the proper understanding of the provision at all. For example, there are so many. The last time I checked, there are about 50, provisions in the Constitution where a similar phrase is used that the President may do something or Parliament may do something. For example, the Constitution says that the President may appoint ministers. That is clearly a discretionary power, right?
Right.
And there's no CI who guides the president's appointment of who becomes a minister. Does that mean that all the ministers that the president of Ghana have been appointed from 1992 are unconstitutional? For another one, the Constitution says that the president may enter into international agreement with other nations. So far, there's no CI who regulates what kind of agreement the president may enter and for what purpose. Does that mean that all the agreements that we've been signing with international organizations in other states is unconstitutional?
Right.
A third one is that the president may grant pardon. They grant pardon to persons who have been convicted. There is no CI, as far as I'm aware, regulating whom the president should grant pardon to and under what circumstances the president may grant a pardon beyond what is in the Constitution. Does that mean that all the pardons that the presidents have been granting? So, you see, the whole point is empty as far as law is concerned. It lacks any serious legal basis.
Right.
But then again, like I said, anyone who goes to a meeting, if they are in a majority, they can pass any resolution they want. It does not in any way suggest that the resolution
is binding. Okay.
It's a valid legal opinion which someone must
follow. Right. But Mr. Stremsai, briefly, and if you can help me with that, many people are interested to know what the prima facie case is. The Bar Association, for instance, is asking that it be made public or should be released by the president on how he arrived at the reason why the Chief Justice has been suspended. Is that a fair position, or would you advise the president to do that?
This is the lowest point of the community. You and I are aware that the Constitution said that the proceedings of this, the proceedings involving the removal of the Chief Justice should be made private. The proceedings should be made private and not be made public. So if a group of lawyers meet at an event and decide that the best call they can make is to call the president to make that which the Constitution says should be private, should make it public. What does that tell you? Is that not a group of people who are determined to either subvert or to overcome or to circumvent the Constitution? You don't need to go to law school to understand that when the Constitution says something should be private, and the series of court decisions confirm that the proceedings, including the petition, the responses, the conversation about which should remain private, how can you then go to a meeting and say that as a group of lawyers, we want the president to make it public? If you have any intention of changing the position of the law, what you do is to seek an amendment of the law, but to say that the law should remain so, yet let's do something else, is to act unconstitutionally.
Okay.
And so it is shocking that the Ghana Bar Association, and the members who attend the meeting could reach such a
we are grateful for your time.
That reasoning is faulty. It's faulty in the sense that it is assuming that when a CI is not published, then the person who is giving
So that's the voice of the Deputy Attorney General and Minister for Justice, speaking with my colleague Martin Asiedu Date. I'll be speaking with lawyer Osman Al-Hassan soon. He will join us for the entire conversation. And lawyer, thank you so much for staying with us on the line throughout. But let's begin the conversations right now. You have seen the statement from the Bar Association. It has elicited lots of reactions from different quarters, different personalities speaking about it. What has been your reaction since you read it?
My reaction has been that it is embarrassing, and I feel most embarrassed at this point as a member of the GBA than ever, because the GBA has revealed a terrible inconsistency in its own stance in this procedure that put the reputation of the GBA at risk in the sight of the public. I will not be surprised, and I'm not surprised, that citizens have started expressing some decline in confidence in the GBA and asking questions that would otherwise not be asked of an association in the stature of the GBA. The GBA had earlier issued a statement that's through the president of the GBA, saying that because issues about these matters are pending in the Supreme Court, it does not want to make a pronouncement. And you will remember that in your earlier interview with me, when you were comparing the GBA silence with some people's voices, I said I respected the GBA silence, and I told you that it was because the GBA was knowledgeable in law and knew they understood the entire process and what ought to be done at that stage. That was a misplaced confidence I expressed, I should think now. And a few days later, the GBA issued a statement, which can still be said to be a little balanced, because they said issues were pending. They didn't want to interfere with pronouncement and position in the procedure. And also, but they declare their resolve to uphold the Constitution, to uphold rule of law, and to uphold fairness and justice and all that, which is fine. Now, a few days later, the same GBA, for the first time, I have never heard that the GBA issued a statement as a result of a resolution arrived at a conference, to be honest. On national issues, I have never heard that the GBA will have to convene or hold a conference and then arrive at a conclusion on matters of national importance. What we know is that the GBA always expresses its stance on national issues through the presidents of the GBA.
Right.
And most of the time, and we have known that when the GBA deem it fit, it goes to the Supreme Court or the appropriate forum to enforce or uphold the law.
Osman, let's try and go through the, if you like, the demands of the GBA, and we'll try and box all of that together in maybe about 5 minutes. First is the revocation of the Chief Justice's suspension, deeming it unconstitutional, and enactment of clear regulations to guide Article 146 proceedings on the removal of justices. Briefly, from where you sit, what do you make of this first demand?
Okay, so this first remark, this statement reveals some level of ignorance, which I don't expect to be in the GBA and the caliber of people who lead the GBA. Now, do you know what it means for someone to say revoke? To revoke means the thing is already in place. They are not saying that it be nullified. They say the president should revoke, which means that it is an acknowledgement that something has been done legally, but they want it to be undone legally. Now, if you say the president should revoke, the first thing is that on what authority are you saying the president should revoke? Because you are not the Supreme Court. And you didn't go to Supreme Court asking for an order of the Supreme Court against the president to revoke the suspension.
Okay.
Now, even if you say the president should revoke, you see the Constitution also has made provision for revocation of that suspension under Article 146, Clause 11. He said the president may at any time or any stage of the inquiry revoke the suspension of the Chief Justice. Now, that is also a discretionary power. Now, if you say the president should revoke, is the revocation not supposed to be under Article 146, Clause 11? Or they want it to be revoked based on their statement that was published? Now, if the revocation is going to be under Article 146, Clause 11, which is also an expression of a discretionary power, then they should wait until the rules and regulations are put in place.
Right, I see.
To guide the exercise of that discretion.
Okay. So, lawyer, there's also the demand for the immediate release of the decision establishing a prima facie case against the Chief Justice. And under that, we're reading condemnation of political commentary that undermines judicial independence and a pledge to protect the judiciary from such interference, particularly the release of the decision establishing the prima facie case against the Chief Justice. Does that sound to you, briefly?
Okay, so that reminds me of a statement our Venerable Chechu Chikata said. He made some time. I can't quote him exactly. But he said, you see, the overthrow of the Constitution is not only by people with guns. It can also be done by people in wigs and gowns. Now, this, for me, is a clear manifestation of an overthrow of a constitutional provision. And listen to, I think, the Deputy AG, who made it very succinctly, that the procedure under Article 146 in itself, I think Clause 8, makes it imperative that the procedure, the whole procedure for the removal of a superior court judge should be confidential, should be held in camera. In camera means it has to be confidential. It doesn't have to go into the public. Now, the question we ask ourselves is the prima facie determination part of the proceedings of the removal of the Chief Justice? The answer is yes, even if you don't read law. Even if you haven't read law and you read this, you will know that determining the prima facie case is part of the procedure for removal of the Chief Justice. And the Constitution says we should make it confidential. I am not saying that no one can advocate for an amendment of the Constitution, but if you are not advocating for an amendment of the Constitution, but you are advocating for a conduct that will violate a provision that you think should be otherwise, That is an overthrow of the provision.
Okay. And counsel, maybe...
And that is reasonable, let me say, add that.
Okay. And maybe, sorry, but maybe in about 30 seconds. Lastly, on the court case assignment, the GBA is calling for the withdrawal of the directive by the acting Chief Justice. I'm talking about Justice Bafoboni, on assigning new cases and advocates for enhanced use of technology in the process. Briefly, counsel, how do you respond to that?
First of all, the GBA has no authority to give that order.
Great.
Or whatever they say. They don't have that authority. It is the Supreme Court who can issue an order upon hearing a challenge of a constitutional provision in that regard.
Right.
The GBA did not go to the Supreme Court to get the order. They are making their own statements that be revoked. Number two, are they saying that the acting Chief Justice is not the person to perform the functions of the Chief Justice now? Or they are saying that the aspect, what they're asking him to revoke does not form part of his function as a Chief Justice? Because if the Chief Justice is suspended, what it means is that everything regarding his function as a Chief Justice is on hold.
Counsel, thank you.
And the Constitution permitted that someone else act in her stead. And that person is acting in her stead, and part of the function of the Chief Justice, and of course that person, is to assign cases. Counsel,
thank you. Thank you so much for speaking with us. Osman Al-Hassan is a private legal practitioner sharing his perspectives on the latest development concerning the Ghana Bar Association on the removal of the Chief Justice there.